I think what you heard and saw today in the courtroom was a bench that was fully aware of the difficulties that the states have been in under the court's voting precedents. If you know Louisiana's story, you know that for the past couple of years, we have been struggling to find a map, a congressional map that satisfies the court's precedents. It's been extremely difficult. We argued it once earlier this year. We're back here. And what I told the court at the podium is, look, at the end of the day, we really need clarity. The states need clarity on how they're supposed to comply with the Voting Rights Act and with the Equal Protection Clause. I think at the end of the day, that's what we're hoping the court will give us, and the court was extremely engaged. I mean, a 2.5-hour argument these days is almost unheard of, so we're very grateful to the court for the time that it gave us and the ability it gave us to express, you know, our concerns with the jurisprudence and how we think we can make it better.
Y'all have any questions before we move on? Well, every time they handle a Voting Rights Act case, it has enormous implications across the country, and we're talking about congressional representation. You know, we've been mired in litigation over our congressional maps, not just during this decade, but since the 1990s. So, you know, we think the court needs to clarify its own rulings and make some sense of them. And what we heard today is that that's really hard, even for them. So we've said all along that you have to look at how the population is distributed and look at how maps can be done legally and constitutionally. And that was the basis on which we defended the first map that we drew that was part of the Robinson litigation. And so, you know, I think that we've been over and over this argument about proportionality. Proportionality is not the test. And so, you know, I think we are all bound by the rules that apply. And the court has made that even more difficult with confusing precedent on telling legislatures what they can and cannot do. Milligan was the most recent case, not counting the Charleston County case. The Milligan case basically said you can think about race, but you can't think about it too much. That is not a workable standard. Our legislature passed a map that had been pre-cleared twice by the Justice Department and had been largely implemented after lengthy litigation involving prior maps where we did try and draw another majority-minority map that was struck down by the courts. So, you know, our legislature has been acting in good faith, not just this decade, but for decades past, in trying to comply both with the Voting Rights Act and with this court's jurisprudence. It is an impossible task. And so, you know, they need to fix this. This is real, you know, the job is clear from our standpoint that the court needs to fix this because we think the court is what's broken the process to begin with. Good? You know, in my opinion, that makes it easier to fix, not less easy to fix. I hope that they will see it that way. I mean, you know, our case has just always been, I think, a good vehicle for illustrating the problems with the court's jurisprudence in this area. Our legislature has, in good faith, tried to comply, not just this time or the last time, but for decades. And, you know, so they are the ones that have to struggle with making sense out of some very vague terms and very vague tests that have been created that just ensure that we are going to be bogged down in litigation no matter what we do. We are damned if we do, we are damned if we don't, and that's what our case illustrates. I don't think his arraignment has been scheduled yet. And I'm expecting it, I'm not promising, but I'm expecting that it will likely be a remote arraignment from Angola. They've already been arraigned. And he's been charged, and we expect there to be an upgrade in those charges, but he has been charged, he just hasn't been arraigned. He was charged in absentia. Oh, he just said he was arraigned today and pled not guilty over Zoom at Angola. So it happened while we were in court. Yeah. Good? All right, thank y'all very much. Our clients are not coming too? Okay. So just go? Oh. Good afternoon. I'm Janae Nelson, President and Director Counsel of the Legal Defense Fund. We're just leaving the court after arguing Louisiana versus Callais, where the court asked some very challenging questions about the future of Section 2. We feel confident that if the court relies on its precedent, if it continues to have a commitment to the 15th Amendment and to this project of multiracial democracy, that it will rule in our favor. There has been no change in conditions or the law since it decided Allen versus Milligan a mere 28 months ago, where the court reaffirmed the constitutionality of Section 2, where the court rejected many of the specious arguments that our opponents have asserted on this second argument of the case. And so we feel very confident that the law is absolutely on our side. I want to take a moment, though, to thank our plaintiffs who have continued this fight, this battle, not only for fair congressional maps in the state of Louisiana, but fair legislative maps, fair judicial maps. It takes the will and spirit and courage of everyday people and voters to put themselves on the line, to commit themselves to often a very long and protracted project of ensuring our democracy. And while we are fighting for the rights for Black voters in Louisiana and across the country to have an equal opportunity to participate in our electoral process, that win is a win for democracy. It is a win for all Americans. It is a win for the rule of law. And that is why we fight, because we believe in the future of this country, and we believe that Black people have a right to be part of it and to self-determine who will represent them and to be part of the future of this country. And that is what Section 2 of the Voting Rights Act secures, and I'm happy to take your questions. Yes. If your question is the broader implications of this ruling, my hope is that this will put to bed the constant efforts to undermine Section 2 of the Voting Rights Act and the Voting Rights Act as a whole. There are constant challenges to its constitutionality. There are ways in which those states who are recalcitrant and do not want to abide by the Constitution try to litigate every factor
of Section 2 and of our voting rights jurisprudence. I hope that the court writes a decision that is firm, that is airtight, and that forecloses any future challenges on those lines. Yes. I know that the court issued an extraordinary decision in a case that we argued, Allen versus Milligan, and won, even when people made the very same argument that this court would not necessarily rule in our favor. We have every confidence that this court will do its job, will follow stare decisis, and understands the import of this case, particularly in this political context, where its legitimacy matters most.
We'll take two more questions and then we're going to the press conference.
Yes. Well, we're a nonpartisan organization. We bring this case on behalf of voters regardless of who they vote for or what party they may or may not be affiliated with. What we care about is the right of every person to be able to vote without dilution, without discrimination, and that is our primary concern. We are not concerned with the objectives of political parties. Hearing no further questions, thank you.